Disclaimer: the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. Hello, welcome to the opening statements section of the University of La Verne Justice Center website. Glad to have you. Now that a jury has been selected, it is now time to begin your trial. The opening statements take place at the beginning of the trial. The party with the burden of proof, the one who brought the action to court, gives their opening statement first. Once the prosecution is finished, the defense gives their opening statement. After the opening statements have been recited, witnesses and evidence are examined by both parties. The purpose of opening statements for both sides is to give the jury an outline of what they can expect to see throughout the trial. If the trial is considered a movie, then the opening statement is the trailer to that movie. This step is important to preface what the jury is going to be hearing and seeing in court, so that they are prepared for the evidence that is going to be presented. Opening statements are not required. However, if you choose to skip this step, the jury will not know what evidence to expect to hear and see from your side. This can hinder the jury's understanding of the material being presented. This is important because jurors usually make up their minds prior to when they should, many times during jury selection and opening statements. During this step, you are giving a first impression of the case. You want to create a factual statement that is going to foreshadow the evidence that the jury is going to be seeing and hearing during the trial. The opening statement should not be too long to the point where the jury and judge lose interest. It should be a strong, concise statement that summarizes your points and draws in the jury. If your opening statement is too long, the judge may instruct you to stop and move on with the trial. The opening statements take place at the beginning of a civil trial. Through opening statements, each party informs the jury about what evidence they will present and what the evidence will prove. The opening statements allow the lawyers to present their positions to the jury prior to the introduction of the evidence. The trial begins with the opening statement of the plaintiff, whose objective is to prove its case in order to be successful. The defense lawyer then follows with their opening statement. Either lawyer may choose not to present an opening statement. Opening statements should include the following: a hook to get the jury's attention, for example, things are not always as they seem. A theory or theme, this is one sentence that summarizes your case and it should be repeated throughout your presentation to guide how you are going to present your case. A summary of facts, this is a few sentences that provide a summary of the relevant facts of the case for the jury to understand what to expect. A summary of law, this is what the jury is going to be deciding and what is your burden of proof/persuasion that the parties must meet. A summary of witness testimony, this introduces your witnesses and summarizes what the jurors can expect to hear from them. A request, which lets your jury know what you want them to do for you based on the law and evidence. And finally, a conclusion that ends your statement strongly. For example, this is the only verdict that will be supported by evidence. Thank you. This has been an overview of the opening statements section of the law. On behalf of the University of La Verne Justice Center, we thank you for your time and hope this information is helpful in your legal matter.